Hello, welcome to the Disability Law Question and Answer session with me, Martin Willemse. I'm a partner at Samfiru Tumarkin and the Western Canada Disability Practice Leader, where we deal with insurance cases, which would include long-term disability, life insurance and critical illness, mortgage insurance, and sometimes travel insurance as well. We have offices throughout BC, Alberta, and Ontario, and represent clients throughout Canada, other than in Quebec and the territories. So welcome again. Please send your questions through social media and YouTube, however you want to send them, and I will review them and respond. So hopefully within the next 30 minutes, you will get your questions answered. One of the things that we are going to discuss today is how disability claims through group insurers. In other words, as an employee, you would have group insurance through your employment. So if you do apply for long-term disability benefits, that would be pursuant to a policy, which is a contract. These contracts have provisions that allow insurance companies to deduct benefits from other sources. So the question often arises, how do workplace injuries interplay with WCB, I suppose, as well as the long-term disability benefit? And the question is, what do you do if you do have a workplace injury? First thing would be you speak to your employer and ensure that you submit a claim to WorkSafe, be it WorkSafe BC or WorkSafe as it is named in other provinces. And also, and this is the important feature that many people do not understand and what many people do not do, you ensure that at the same time, you also submit a claim to your long-term disability insurer if it is the case that you have a disability that is ongoing. Normally, there would be a qualifying period before you get to LTD. So some insurers may provide that there is short-term disability benefits available. Others will require that you have a waiting period, be it 3 months or 4 months, sometimes 6 months, and then it transitions into LTD. If it looks like it is going to go into long-term, in other words, beyond the qualifying period, you should submit a long-term disability claim, even if you have submitted a claim to WorkSafe and even if the claim is being paid by WorkSafe. Now, many people will think that they should not do that or do not have to do that because they're already getting benefits from WorkSafe. So why would they need to submit a claim to the long-term disability insurer? The reason for that, there are certain provisions in the policy that provide that notice of claim and proof of claim must be submitted with a certain period of time. Often it would be 90 days, notice would be 30 days, proof of claim would be 90 days from the date of the injury, or depending on the language of the contract, the date that the shortened period ended. Many people find that they don't do that, and then when WorkSafe stops paying them, then they get in a position where they want to submit a claim to the long-term disability insurer, and the insurer then says, too late, you submitted the claim too late, you missed the contractual deadlines, we do not need to pay. If that does happen, if you are in a position like that, obviously you cannot fix what has happened in the past, do reach out to our firm because we have represented many people who have submitted their claims too late. Doesn't mean that the claim is necessarily fatal and doomed to fail. We can assist you with trying to navigate the system in order to still get you benefits. And as you can see on the screen, you can contact us to find out more by going to disabilityrights.ca. Another thing that should happen is, and this is a more complicated discussion, if you are receiving WorkSafe benefits and you did submit your claim on time, but the insurance company denied your claim, but WorkSafe continues to pay, there is a 2-year timeline, depending on which province you're in, that runs within which you must file a legal claim. So regardless of whether you are receiving WorkSafe benefits, you must still submit or at least appeal the decision if that's where you wanted to go, but make sure that you do not miss the deadline to file a legal claim if your claim remains unpaid, because you don't want to be in a position where WorkSafe pays you for 3 years, then denies your claim, and the insurer denied your claim 3 years ago, and now you're too late to pursue a legal claim. So again, these are complicated matters, but the gist of it is, if you have a workplace injury, you must submit a LTD claim as well. At the same time, if it is denied, reach out to a disability lawyer, contact us, and we can discuss your options with you to make sure that you can protect your own legal rights. We've got a question from Chrissy T. My sister is currently appealing a claim with her insurer because they said she has insufficient evidence. What would be the best way for her to proceed? Is there a good way to handle an appeal? When a claim is denied by an insurance company, they are often denied because the insurer says there's insufficient evidence. We speak to people about this on a daily basis. We've got, as I say, my team members field questions from the public regarding LTD claims that have been denied or that may be denied when the person suspects that there's something coming down the pipe. Many of them are denied based on the insurance company saying that there's insufficient evidence. An example would be the doctor says my patient has depression, therefore they cannot work. That claim is going to be denied. The reason for that is lots of people have depression and work. Why is it that this person cannot work? There needs to be an explanation. Evidence needs to be submitted. Now, I can speak for hours and hours about mental health claims and how these are denied and how they should not be denied. But the point is, when you submit a claim, the evidence that you submit must detail what your restrictions and limitations are. In other words, what is the functional impairment? For example, going back to the depression case, if you have depression, some of the telltale signs may be, or symptoms may be, inability to focus, concentrate, poor memory, oversleep or undersleep, inability to multitask, very poor motivation, low energy, profound fatigue. Often you would have an anxiety condition coupled with the depression, which would also lead to agoraphobia. Some people may not want to leave their beds. They struggle to interact with others, very low mood, crying spells, panic attacks. Detail that in a letter from the doctor explaining what the restrictions and limitations are together with the diagnosis. If medications are being taken, detail how the medications may be affecting the person's cognitive functioning. In other words, it may affect their thinking, their focus. It may lead to brain fog. Detail what the occupational duties are, not her job, but her occupation. What are those duties? And then conclude by indicating how the restrictions and limitations would impact her ability to function in her occupation. But I also suggest that she does reach out to us because we can discuss with her what her options are. We can review the denial letter, see what the policy says, if she does have a copy of the policy, look at the medicals, and then explain what the options are, how to manage this. I'm using mental health as an example. This may not be a mental health situation. So there are details that need to be communicated from the doctor to the insurer to underscore why the person is unable to work. In this case, your sister. She may also have an opportunity to pursue a legal claim, which is what we do. And it is something that we can assist where she doesn't have to deal with the insurance company at all. All communications go through us. Christy says, thank you. She's dealing with mental health claim. Okay. The anxiety of dealing with the insurer is making her worse. It should be illegal for them to treat types of claims like this. You know how often I hear that? And it is common sense that when a person has a mental health claim, it's already very stressful that they have gone off work, that they are dealing with an insurance company, that they do not have the financial support, all within the context of living with mental health issues, meaning anxiety, like we can see here, depression as well. Not being able to work already increases that. It's not a positive prognosticator. In addition to that, feelings of self-worth often are harmed by not being able to work. It's not a good position for anyone to be in. Therefore, when you do speak to an insurance company and a case manager, when you submit a claim where you have reached the point where you cannot work, you do want them to treat you with empathy and understanding and have a reasonable approach. Sometimes that does happen and sometimes it does not. So dealing with the insurance company, as you're saying here, it's making her condition worse. I strongly advise that she reaches out to our firm so that we can discuss with her what our options are. Because as I said, if it is a situation where we are retained and we get involved, all communications go through us and the client doesn't deal with the insurance company. They're no longer speaking to them and they can focus on their treatment and hopefully improving their health. Again, as you can see on the screen, contact us to find out more. Go to disabilityrights.ca. I hope that was helpful, Chrissy. I'm sorry that your sister is going through this. And again, if there's any further questions, let her reach out to us. We do offer free consultations, so to just be clear about that. We would want to look at the medical information in the denial letter so we can be in a position to advise her and she can make an informed decision as to how to proceed. There's a question on YouTube from Mina. Can a disability lawyer help with an LTD claim for a union worker? This is an interesting question, and it does come up every now and again. In some cases, yes, and in some cases, no. It depends on what the provisions are in the collective agreement. For example, who is the payor? Is it a trust where the insurance company is not actually paying, they're not underwriting the benefit. The benefits are paid by a trust, and the insurance company's only role is to provide administrative services. In other words, they adjudicate and make decisions, but they don't pay. They have no legal nor financial liability. Those make it more difficult. In some cases, you have to go through what is called a claims review committee as part of the appeal process, where they don't, depending on the circumstance, where lawyers may not be allowed to attend. So it's not a yes or no response. It depends on which union it is. It depends on what the collective bargaining agreement provides for, whether there is a mandated appeal process versus whether you can actually pursue a legal claim. Excuse me. We have another question. Let me just see what it says. What is the difference between PWD and LTD? And this is a question on YouTube from Jason J. This is a good question. So when I see PWD, that tells me that the person is in British Columbia. PWD stands for Persons with Disabilities. It is, you get PWD payments once you have a PWD status. It is not income replacement. This is an argument I have with insurance companies all the time. PWD is based on the inability to work and having medical impairments that would be deemed to be a disability. It is paid by the provincial government, and it is social assistance versus income replacement. In other words, there is no duty that you need to contribute to a plan like Canada Pension Plan, where you then are allowed to obtain a pension disability from CPP, which in LTD policies would be an offset. So from the LTD benefit amount. PWD, as I said, is paid by the provincial government. There are various organizations in BC which would work on a non-profit basis helping people to apply for PWD. It is based on a means test as well. So they look at what their household income is. If you live with somebody who's earning, say, $60,000 a year, you may not qualify for it because they're looking at what their household income is. So there are various criteria which you need to qualify in order to get PWD. But I often advise people, if they're not getting any money from the long-term disability insurer, to apply for either CPP disability, which is paid by the federal government, but there the position is the condition has to be severe and prolonged to the extent that the person cannot work in any gainful occupation. If all of those questions are answered correctly, or answered yes rather, and the person has made sufficient contributions to that plan, then they may qualify for CPP. CPP is a direct offset from LTD benefits. PWD, my position on this often is if you, long-term disability insurer, paid and approved and paid the claim, the person would not have applied for PWD, very likely not, and very likely would not have qualified because there's a financial test to see whether you would qualify. Obviously, if you're not getting long-term disability and you're not getting any other benefits, you should be able to qualify depending on what the household income is. If there's a position where the insurer is saying we're going to deduct PWD from LTD, that is something that I'm always opposed to, but it depends on the language of the policy. We have a question from Bren. When is a medical condition considered pre-existing? If you have a type of arthritis that is slowly worsening but have been dealing with it for several years, would you still be able to get LTD? I suspect I know why this question is asked, and it's a very good question. Again, this is there's going to be a very long discussion. I'll try and be as short as possible, but also as detailed as possible. If we're speaking about a long-term disability policy, which is a contract that you have through your employer, so it's a group policy, the vast majority of them, if not all, will have provisions that say that if you have a condition that is pre-existing, in other words, your disability is related to the pre-existing condition, then you do not qualify for benefits. Your claim is excluded. But there are limitations to that provision. The first one is, for the most part, if you have had coverage for at least 1 year and you go off work due to your disability beyond that year, then the pre-existing condition should not apply. Some policies will have the pre-existing condition to be 2 years, but many do not. For the most of them, it would be 1 year. So if you do go off work within the first year of having coverage, then they're going to investigate whether it was pre-existing. Pre-existing will have a specific definition. It's not the average day lay person's idea of what a pre-existing condition is, or even in the medical field. Pre-existing means it's something that I've had in the past, but in a contract, that's not what it means. It is very fact specific and it is time limited. Most policies will provide, for example, I'll use an example. If you have gone off work within the first year, then they're going to look at whether it's pre-existing, and they're going to look at a specific time frame. And that time frame may be that you have gone off work within the first year due to a disability that is related directly or indirectly to a condition for which you had treatment during the 90 days before you had coverage. Or it may be during the 90 days before you had coverage or the 90 days after you've had coverage. Others may say, if there is any moving 13-week period during which you did not receive medical treatment, as that is a defined term, then it is not pre-existing, even though it is something that you've had all your life. Medical care is important, but it really depends on the nature of the policy. So what would medical care be? That is another defined term. It may be if you saw the doctor on a regular, if you did see the doctor for consultation, if you were treated, or if you were taking prescription medications. So bring to you, it may be that you've had the arthritic condition that was slowly worsening, even though you were coping with it. If you were being treated for it during the pre-existing window, and it is that condition that later on led to you becoming disabled within that first year of having coverage, the question is going to be, did you receive treatment for a condition that is directly or indirectly related to your current disability during that specific period of time? If it had been a 90-day issue, so your coverage kicks in on April the 1st of whatever year, and you had, so the 90 days would be the period before, so maybe January up until March, and you had treatment for your condition that led to your disability up until, say, November, and then things got better again, and you didn't have it during those 90 days, then it's not pre-existing. It really depends on the language of the policy. I speak to, and I know other members of my team speak to people with denied disability claims because the insurance company says that the condition was pre-existing. I really would like to look at the medical records, what the definition is. I've had lots of cases where the insurance company would say it's pre-existing, but I don't think that the care the person was receiving was medical care as that term is defined in the policy. Or they may say it was pre-existing. The person received treatment for anxiety when the disabling condition actually is depression. They say it's pre-existing. There are arguments that we can raise. And another thing to know is when the insurance company denies the claim based on a pre-existing condition, we say that the duty to prove that is reversed. You have a duty to prove that you're disabled, but if they're denying the claim based on a pre-existing condition, they have the duty to prove that that actually is a proper denial. Sometimes it is, but sometimes it is not. So it is very fact specific, and I'm happy to have a discussion with you, with one of my team members, to review your claim, your circumstances, and to tell you whether we think that there is a claim that can be pursued yet. And again, as you can see on the screen, go to disabilityrights.ca to find out more. Okay, hopefully that was helpful, but I think, again, you need to have, we need more information. A question on YouTube from GFUD, if that's correct. Who picks your job after 2 years when switching from own occupation to any occupation? Okay, so nobody picks your job. The way that this is done is there's an assessment done by the insurance company. Now, they make decisions ultimately whether they're going to pay the claim or not. Whether their decisions are correct is a whole different discussion, right? We often disagree that their decision as to whether a person is able to work in another occupation is incorrect, and therefore we get involved with legal claims. We represent our clients. So who picks your job? Nobody picks a job for you. How this works is you submit a claim to the insurance company saying that you are unable to work in your own occupation. If it gets to the point where there's a change of definition, so after the 2-year timeline, you've received benefits for 2 years from the LTD disability insurer, now the definition changes. Now you, as the person making the claim, must prove that you are unable to perform the duties of another occupation. And that's not any occupation, it's another occupation based on your transferable skill sets. In other words, based on your education, your training, and your experience. And importantly, something that may assist you. Something that is commensurate to what you were earning before you became disabled. In other words, something commensurate to your pre-disability earnings. Some policies may provide that there is a percentage. So the policy may say that after the 2-year mark, after the unoccupation period, when we're looking at the any occupation period, we're now looking at, can you perform the duties of another occupation, any other occupation, based on your education, training, experience, which would pay you roughly 75% or 50% of your pre-disability income. If the policy is silent on that, in other words, if there's no provision with respect to the percentage, then we look at the common law position, which may be something similar to your LTD benefit. So say you get 67% of your LTD, of your pre-disability income as your LTD amount. The question is going to be, is there a job that you can perform based on your transferable skills that would pay you roughly the same as your LTD benefit amount that you could perform within your medical restrictions and limitations? So nobody's going to go out and find a job for you. That's not the insurance company's job to do. That's not their duty. The issue is that job out there? Many policies will say the availability of a job is not a consideration. In other words, you don't need to be able to go and find the job. The only consideration is there a job in the open labor market available in your province that you could theoretically do? Then they deny the claim on that basis. And that's where we step in, because many cases get denied at this juncture, at the change of definition, where people feel overwhelmed and say, okay, well, the insurance company says I can no longer work my own job, but they say I can do another job, so maybe there's nothing I can do about it. There is. Now, I often tell people, go speak to your doctor, where the doctor still supports that you cannot work in another occupation, which doesn't mean any occupation. It does mean, though, it's not limited to a job at your employer or even, the same occupation as I said before. It's any employer in any setting, even working from home. But if you have a mental health illness, like we was discussing with Bren this morning, Chrissy, your ability to concentrate is a requirement in all jobs. So these restrictions and limitations permeate into other jobs as well. And the question is, can you perform the job on a consistent basis, on a reliable basis? If the response is no, then we say you should still be receiving benefits. And again, that's where we get involved. So if you've got a question on that, if they are denying your claim at the change of definition, reach out to us and we'll give you some options which you can then consider to make an informed opinion. Question on YouTube from Paula. My doctor has recommended a treatment that my insurance company is refusing to cover. I'm worried that not going to my treatment will result in my coverage being cancelled, but cannot afford it without assistance. Is there anything I can do? Okay, it's remarkable how many times people ask me this question, and I understand why. Insurance companies under a long-term disability policy have certain duties. One of them is to pay to you LTD benefits if you are unable to perform the duties of your own occupation or any occupation, depending on where you are in the policy. You are not entitled under the policy, the LTD policy, to have the insurance company pay for your treatment. Having said that, because that's not an obligation that they have, their duty is to assess claims and to pay them. But they don't have a duty to pay for your treatment. But having said that, in practice, it happens so often that insurance companies do decide to fund treatment, but only when they decide it's beneficial to them. They're not funding the treatment because they're trying to help you to get along. They're funding the treatment because they believe that if they do that, it will be financially beneficial to them by paying this money now So if you're going to get treatment, say with a psychologist, 12 sessions, it may cost them under $2,000. And it may carry on for about 3 months. So they're going to pay you your LTD benefits for 3 months and then pay another $2,000 on top of that, with the expectation that at the end of those 3 months, you're going to be in a position where you can return to work and they will be able to deny the claim. That would be the expectation. But if the expectation, if they look at the evidence and they see, well, if we're going to fund this very expensive treatment for you, Paola, but it may not result in any improvement, they're not going to do it because it's not financially viable and it's not in their financial interest. They will only do it if they can shorten the life of the policy, or rather of the payment. In other words, they will pay extra money to fund the treatment, but then they won't have the exposure to pay LTD benefits on an ongoing basis, even after they've paid that benefit or that treatment. So for you, I just want to make sure that you maybe can try and get it covered through your extended health coverage, because that would be a good idea if it is available. See if you can get fair pharmacare or get some other form of funding, and make it clear and have the doctor make it clear to the insurance company that if you don't get this treatment, there's no expectation that there will be any improvement. And if they do deny you later on, because they do that, they may say, we're going to deny your claim because you are not going through the appropriate treatment. If you don't have the finances to attend that treatment, they cannot have it both ways, which would be my position. And there's case law on this, even though they do it in practice. They may say to a person, you are not being appropriately treated. You're not following through with treatment advice, which is something different. And the person may say, well, I don't have the funds to do that. How must I do this? I have difficulty paying my rent. How on earth must I pay for treatment as well? These are messy situations, but we can navigate them. So if that does happen, if they do deny your claim because they say you're not following through with this expensive treatment, which they refuse to help cover, I think that there's a claim to be argued. And again, reach out to us and we will discuss with you what your options are. We have a question from Tracy on YouTube. It says, currently on LTD, but my insurer wants me to see an occupational therapist to set up a return to work plan. I'm not ready for that, and my doctor has said I'm not ready either. What can I do about this? Difficult. Like, remember what I said, insurance companies have certain obligations under a policy. They also have certain rights. If you refuse to attend an assessment, then they may say that you are breaching your duties under the obligation, under the policy, and they may deny your claim based on that. If it is a situation where attending the assessment is going to worsen your condition, in other words, exacerbate the condition, and has the potential then to have you stay on claim for a much longer period, in other words, that it may actually be dangerous to your health to attend, that's a different situation, because then I would have the doctor put in writing why that is, explain what can and cannot be done, and then submit that to the insurance company to see what their position is. But ultimately, taking a step back and looking at it objectively, the insurance companies do have a right, based on their policies, to have you attend assessments as they deem them to be necessary. Whether your doctor agrees that you're ready to return to work is not the issue. If they do deny your claim based on the fact that they've sent you for an IME or for a functional capacity evaluation with an occupational therapist, and that person says that you are ready to return to work, and they deny you, you have a claim to argue there if your doctor still supports that you cannot work. But can you simply refuse to attend the appointment unless it is something that's going to potentially worsen your condition? If you do that, you're putting yourself at risk that they may deny your claim in any event. Remember, if there is a situation where the doctor says, look, it poses risk to you, maybe have the insurance company put in writing to your doctor to explain what type of testing is going to be done, and have your doctor then comment as to whether it is appropriate for your condition. But if the position simply is you're not ready to return to work, they can still send you for an assessment. Now, of course, if they deny you based on that, and you and your doctor still say that you cannot work, by all means, reach out to us, because at our end, when we get involved, we often, through the course of the legal claim, have our own assessments done, where we get people commenting on the capacity to work, the restrictions and limitations, and the prognosis for return to work, which we use to support the claim that we are pursuing through the legal avenue. So there's a lot of value in pursuing a legal claim on that basis, because you can access potential better assessments and opinions to support your claim. But again, it is a fact-by-fact and case-by-case analysis. So that brings us to the end of today. Thank you for those questions. They were very good questions. I hope that this was helpful. And if you do have any other questions, please reach out to us. As you can see on the screen, if you enjoyed today's session, please give us a thumbs up. I'm Martin Willemse, partner at Samfiru Tumarkin LLP. Our next session will be on employment law, and that is tomorrow, 1 p.m. Eastern Standard Time, 4 p.m. Pacific Standard Time. And that will be with my partner, Lior Samfiru, who will have a wealth of information to share. Anyway, everyone, have a good day, and I look forward to having another session in 2 or 3 weeks with you. Bye.